Okay. So today's CPD will be presented by Charles Livingston, who is a partner at Brodie's, and also by Jamie Dunn, who is an associate at Brodie's. And they will be talking about public procurement law, basically giving us an update on what's happening on that side of things. So I just hand over to Charles just now.
Great, thanks very much. So yeah, thank you for the introduction. My name is Charles Livingston, partner in the Government Regulation and Competition team at Brodie's, and presenting alongside Jamie, who's an associate in the same team. And Jamie and I each do quite a lot of public procurement work, some of it contentious in terms of procurement litigation, but also a lot of it non-contentious in terms of advising both authorities and bidders in relation to the conduct of procurement exercises. So in terms of what we're going to cover today, we'll take you through some of the relevant legislation, some of the common, we've described them here as common areas of challenge, and that's in both senses of that word. So there are issues that can and do fairly regularly lead to litigation, but also just issues that people on both sides of the procurement spectrum find challenging. So we'll cover in particular direct awards, modifying existing contracts, clarifications with some case law, touching on debrief letters and interviews, and we'll then take you through some other lessons from recent case law, and we'll say a bit about the risk of ineffectiveness of a contract, in particular, given that I imagine that the interest on your part will be as people who bid for contracts rather than public authorities who enter into contracts. Ineffectiveness is one of the key risks from the bidder side. So we'll cover that and we'll say a bit about the processes around that. And then we will close with a little bit on what happens after Brexit. And the reason Brexit is relevant, you'll see from our reminder of the legislation, is that we are still dealing with the procurement legislation that predates Brexit. So the controlling legislation for public procurement in Scotland is still the Public Contracts Scotland Regulations 2015. Those are the regulations that govern the award of contracts above what were the EU thresholds. Those thresholds are still essentially in place. Our thresholds will not necessarily now follow the EU's in lockstep, but it's a similar principle. Those regulations set out a number of substantive duties, both by reference to principles, which we'll cover on the next slide, and by reference to some pretty detailed procedural requirements. Also sets out detailed procedures in terms of a number of different procedural options that can be followed. And the regulations are notable as well for containing a number of rules that are designed to facilitate challenge to contracting authorities' procurement decisions. In Scotland specifically, we also have a layer of procurement regulation below those thresholds, which is set out in the Procurement Reform Scotland Act 2014 and the accompanying Procurement Scotland Regulations 2016. So the names are pretty similar, but they are two separate regimes. So there are lower thresholds, which we'll look at in a moment. There are not quite as many substantive duties. The same overarching principles still apply, but the 2014 Act doesn't put in place quite so many administrative burdens. It still has requirements to advertise contract opportunities, and it still has, it sets out criteria for excluding particular types of bidder or particular bidders from a process and on how bidders should be selected. But possibly crucially, and probably the reason there has not been any procurement litigation under the 2014 Act, at least not that's made it into court, is that it doesn't contain the same provisions for facilitating challenge. I've mentioned Brexit here. We will come back to Brexit in terms of being forward-looking, but from a backwards-looking perspective, Brexit is relevant here in that there were changes made to all these pieces of legislation to reflect Brexit, or more accurately, the end of the Brexit transition period at the turn of the year. They aren't necessarily material. They're not material to the sorts of things that we are talking about. But if you ever are looking at them, just make sure you're looking at the most up-to-date version. So on the next slide, you can see the thresholds that determine whether something is covered by the regulations or by the 2014 Act or by neither. It splits, first of all, by reference to what it is that's being bought, because that affects what the thresholds are. So down the screen left side of the slide, you can see that if you're dealing with supplies, which essentially mean goods and products, whether those are off the shelf or more bespoke, or if you're dealing with services, which will, I imagine, be your principal interest. So things that are not construction services, basically, so legal, accountancy, building maintenance, architecture. Then the thresholds are as set out below. So under 50,000, and this is just the estimated value of the contract, which the public authority is required to estimate, and there are rules around how to do that. Under 50,000, there's basically no obligation under procurement legislation. Many public authorities will still have best value obligations and things like that, but that's really an internal matter for them, or matter between them and their auditor. Then between 50,000 and, as things stand, £189,330 is very specific. You're dealing with the 2014 Act and the Procurement Scotland regulations. And then our former EU threshold, which is sometimes also called the OJEU threshold, OJEU being Official Journal of the European Union. Value over that, then you're into the public contracts regulations, the ex-EU regime. And then on the work side, so you've got under 2 million, between 2 million and 4.7 million-ish. And then above that, you're into the former EU regime. So that's hopefully, it can be quite complicated, but it's hopefully relatively easy to follow the principles at least. And speaking of principles, the key principles that underpin procurement regulation are set out on the slide. Again, these are EU derived, but they do also find their way into the domestic legislation. So they're not in any order of priority. They're all sort of equally important, and you'll see as we go through, they are sometimes in tension with each other. But to put them at their most basic, there's the principle of proportionality, which means that the public authority must not apply any rules or requirements that are not objectively necessary to the exercise that they're undertaking. There's then the connected aspect of proportionality, which is that when making decisions, there's a need to be fair to individual bidders, but there's also a need to keep in mind how the regime actually is supposed to function and the interests that it is supposed to serve. So there's a need to balance that. You shouldn't be overly strict, authorities shouldn't be overly strict when making decisions in respect of individual bidders, but proportionality only goes so far, and they do need to respect both the express rules and the other principles. The next principle is non-discrimination. Sounds fairly straightforward. Usually it is. Public authority mustn't discriminate between potential providers unless this can be objectively justified. So it might be objectively justified in the sense that if an authority needs product X and one provider provides product X and another provider provides product Y, the latter has no right to say to the authority, well, you should be buying Y instead. But if X and Y are very, very close substitutes and really the authority could buy either, then non-discrimination would mean that the procurement should be framed in a way that it's open to both types of supplier to participate. So that's an example of non-discrimination. Equal treatment. So within a procurement exercise, and indeed when framing an exercise, all bidders and potential bidders should be treated the same, and the same rules should be applied to all of them. And the flip side of that is that if bidders are in different positions, then one should not treat them the same way. That would also be a breach of equal treatment. So people who are equal should be treated equally, and people who are unequal should not be treated equally. Then the final principle, often the most important, certainly in terms of the sort of litigation aspect of procurement, is transparency. So the authority should be open and upfront about what its requirements are, what it's looking for, and also how it intends to select a winning bidder or bidders. So what questions people need to answer, how those questions are going to be marked, that sort of thing. So in terms of the duties, and these are broadly similar at this level of generality across the two different regimes. So generally speaking, contract opportunities have to be advertised. The authority has to decide which procedure it's going to apply, and then it has to apply that, and it then has to follow the procedure that it's said it will follow. There are exclusion criteria, as I mentioned before. There are certain things that mean bidders are not eligible, either must be excluded or may be excluded from public procurement opportunities. So having committed various types of offences like bribery or a breach of competition law, for example, can exclude people from contract opportunities. There's an obligation to specify what your award criteria is going to be. In Scotland, at least, for going back a few years now, it's not permissible to have price-only competition. So there has to be a mix of price and quality. That mix needs to be specified, and it needs to be said how they'll be scored, and what aspects of quality they're looking for and how bidders should demonstrate it. Then the final point there, we're getting more into the EU-derived regime. These don't apply to quite the same extent in the domestic regime, but the requirement to produce debrief letters, so telling unsuccessful bidders why they were unsuccessful at its most basic. We've used the word standstill there. So that's the requirement under the EU-derived regime, the higher threshold regime, that a public authority needs to give 10 days notice, at least 10 days notice, before it can enter into the contract. So it gives unsuccessful bidders the information that they're supposed to get, and then gives them a 10-day window in which to challenge that if they're minded to do so. And finally, contract award notices. When a notice is awarded, it closes off with a notice. So the contract is the opportunity is advertised at the outset through a contract notice, and then once it's awarded, there's a contract award notice. So there's a public record and a public audit trail of all of this. In terms of procedures, so there are a number of different procedures that can be used under procurement. Open procedure is essentially sort of come one, come all. Anybody who wants to submit a bid can. Restricted procedure is one you may have encountered that's kind of two stages. So there's usually a simpler and lighter touch stage that anybody can participate in, and the authority will then select, say, the best 5 of those bids to go forward to a more detailed competition to decide who gets awarded the contract. We then get into some relatively, well, certainly less used and probably relatively less well understood types of procedure. So there's competitive procedure with negotiation, which basically opens up, you kind of start with a more normal procurement process, but then opens up a lot more scope to negotiate and clarify and even change bids from bidders after the submission of their initial tenders. And an authority will generally use that if they don't really know how their needs will be met at the outset, and they want ideas, the tenderers to submit ideas and to then negotiate with them once they've established who's capable of providing what they need, negotiate with different bidders to see what it is they're actually going to procure. Competitive dialogue, not too different. So it allows tenders to submit. There will be a selection stage like in the restricted procedures, and tenders can then submit their sort of proposed solutions to the authority, and the authority can then negotiate the proposed solutions with bidders. So not dissimilar from competitive procedure with negotiation. Innovation partnership, that's where there's a need for basically a product or service that doesn't already exist. So an authority wants something, but the thing doesn't exist, so they can't go out and buy it. It has to actually be developed. Use of that procedure does have to be justified, and I don't think it's one we see very often. There's then what is euphemistically called negotiated procedure without prior publication. That essentially means just giving someone a contract, and Jamie will come back to that later on. I've mentioned procurement litigation a couple of times, so some of the key enforcement points that are worth noting, particularly if you're ever considering whether you think you've got a raw deal from a procurement process and are considering whether to challenge it. So it can be done in the Sheriff Court or the Court of Session. They are almost always in the Court of Session. There's been a small number of Sheriff Court cases. I've mentioned the standstill period in which the authority is barred from entering into the contract, and that's one of the facilitation of challenge provisions that I mentioned at the outset. Another one of those is automatic suspension. So that means that if proceedings are served on a public authority, the authority is barred from entering into the contract unless and until the litigation is resolved, or the authority goes to court and gets an order from the court allowing it to enter into the contract. It reverses the usual onus. I'm sure you'll know that normally if you want to stop somebody doing something, the onus is on you to go to court and persuade the court that they should be stopped from doing it. Automatic suspension reverses that onus. To be honest, most of the time automatic suspensions are lifted, but it's still a useful tool in the challenger's toolkit, and even though most of the automatic suspensions that make it to a hearing are lifted, the existence of automatic suspension, I think, does very much help a challenger's, potential challenger's leverage. So it does help get solutions for aggrieved bidders, even if they won't necessarily win if they push the point in court. In terms of remedies, so if a contract hasn't been entered into, you can ask the court to declare that it shouldn't be entered into because the procedure wasn't followed or something was unlawful. Otherwise, if the contract has been entered into, you're normally going to be limited to damages. Compensating you for the money that you would have got if you had won the contract, and discounting it to reflect the chance of you winning it, for example. Although there is also the possibility of ineffectiveness orders, which Jamie will come back to, which essentially invalidate the contract if there has been a particular type of breach in the process. At the moment, I'm going to hand over to Jamie, and then it'll come back to me a little bit later. So Jamie, take it away.
Thanks, Charles. So just going to cover some of, as Charles says, the common areas of challenge, the common areas that can be particularly challenging for both sides involved. So we'll cover the direct awards, that's the negotiated without prior procedure, the modifying of existing contracts, and then some other points about clarifications and non-compliance. So direct awards, which is to say an award of a contract by an authority without going through the process of publishing it and inviting tenders and going through that whole procedural rigmarole that Charles has outlined. There are very limited circumstances in which public bodies are allowed to make direct awards, and those very limited circumstances can often be more limited than public bodies themselves think they are. So it's worth being aware of these. So those are set out in Regulation 33 of the Public Contracts Regulations, and I'll just go through them very quickly. So the first one is that no suitable tenders have been submitted where an open or restricted procedure has been used, i.e. if nobody's come forward, then the authority can make a direct award. Where there's only one economic operator capable of supplying the authority for one of these reasons. So the procurement's for a unique work of art or artistic performance. that obviously just has to be from the artist. There's no competition for technical reasons, or only the provider has certain rights. So, for example, IP rights. But those two subcategories there can be quite tricky, because it's not enough for a public body to say that only one person can supply us with this, because only they, for example, have this type of software we want. What the authority has to do is demonstrate that only that supplier has the type of software in those circumstances that they need, i.e. that there's no other software or something similar that could do the same job. So when bodies are using this ground for a direct award, they do have to be very careful, and potential suppliers who are getting involved in these have to be very careful that the award genuinely does have to be made to that person, because otherwise there's scope for challenge, and that's a risk that everyone's taking. Third one there, that there's extreme urgency as a result of events that are unforeseeable by the authority and unattributable to the authority, which mean there's no time to comply with the time limits for the regulated procedures. So there are time limits set out for when you have to publish things and how long you've got to give people to respond and ask questions and so on. Most of you will probably be aware of those. If the authority doesn't have time to do all of those because things are particularly urgent, then they can make a direct award, but only if they are not to blame for the urgency and they could not have seen the urgency coming. The sort of paradigmatic example of this is the Nationwide Gritting Services case from 2014. This was about the purchase of grit de-icing salt for a couple of what turned out to be particularly harsh winters. And this was done without going out to competitive tender. The Scottish minister said, well, it was extremely urgent. We didn't have grit. We needed to keep the roads running, and therefore we just needed to go out and buy it. And what the court said here was, okay, for the first winter, you're right. You didn't know you were going to need that much grit in those timescales for those times of year. It wasn't possible to comply with the time limits, and therefore it was strictly necessary to go out to a direct award. But for the second year that this case related to, what the court said was, well, actually, you should have seen that coming. You knew that you didn't have grit in place at the right times. You should have learned your lesson from year one and made sure that you had adequate supplies when you needed them. Therefore, it was possible to comply with time limits, just not in the time that you left yourself. And negotiated procedure, i.e. the direct award, was not strictly necessary in the circumstances. So the problem here was the Scottish ministers knew that their supply arrangements were fragile. They could have acted sooner. They could have acted in compliance with the rules, but for their own, by their own fault, they failed to do so. So there was a breach of the regulations here, albeit Nationwide Gritting Services did not get damages because the court said, well, ultimately you wouldn't have bid and you wouldn't have won, so you've not lost anything here. And that's often where these damages points can come down to. So returning to our categories where this is allowed, where the supply contract is, where the contract is a supply contract and it's for any of these products required purely for research, study or development, additional deliveries from a supplier where a change of supplier, I should say original supplier there, sorry, where a change of supplier would mean products with different and incompatible characteristics. So i.e. if an authority has been buying something from one person, and if they sort of changed supplier, the new widget wouldn't work alongside the old widget. Apologies for the widget. Then there's justification to stick with the original supplier to avoid that incompatibility problem. Products that are quoted and purchased on commodity markets, your sort of just basic commodities essentially are capable of being done without going out to tender, and products that are purchased on particularly advantageous terms, so fire sales. Public bodies can take advantage of that type of thing, provided that in respect of that additional supply point that I made earlier, there is a limitation in how long you can carry on with the same person before you've got to go back in any event. Contracts that follow design contests do not need to go out to public procurement for obvious reasons. Once you've gone through the contest, there's only really one person that's going to be able to do it, who's the person who's won the contest. And then contracts for new works, services, or both, which involve the repetition of something that's previously been done by the same supplier, subject to that the previous contract had to be advertised, and it has to be sort of an immediate follow-up to that previous contract. So those are the options for when an authority wants to just make a direct award and not advertise. What about when it wants to modify an existing contract, i.e. to increase, change what it is buying under that contract that's already in place? Well, this is covered by Regulation 72. And what the circumstances where this can be permitted, the first one is that there's a clear, precise and unequivocal review clause. So it's very clear in the original contract as advertised that there could be a change to the scope subject to certain clear conditions, and subject to that not changing the overall nature of the contract. So the idea there is, if it was clear enough when the original bidding took place that the scope of the contract could be changed in a particular foreseeable way, then people who were bidding would have known that, and therefore they would have bid on the basis that that was a possibility down the road. If there's not that review clause, then obviously people might have walked past a previous opportunity because they didn't think that it was for them, and then it's been amended to be for them. So that's what that review clause point is about. Additional requirements where it's not possible to change the supplier for economic or technical reasons without significant inconvenience. So this is very similar to some of the grounds for direct award, but this is obviously modifying an existing contract rather than issuing a new one. So this is subject to a limit that it can't be more, the modification, the additional purchase can't be more than 50% of the original value of the contract. And it's subject to being published in notice as well. Unforeseen circumstances can give grounds for modifying an existing contract, provided that there's no change to the overall nature of the contract, and again, subject to the value limit. Unforeseen circumstances, just think along the lines that I've just been setting out when it came to direct award. Contractual changes can be permitted, provided that a review clause allows for that, and it is only used in certain circumstances. So things like sort of takeovers, restructuring, insolvency. It's obviously not possible just to stick a new supplier in for an old one, but if your existing if the authority's existing supplier has been replaced in a merger or a takeover or so on, then it's possible to do that substitution, provided that the contract allowed for it. And we've also covered sort of where there are the valuation of the modification is less than the threshold, and it's less than 10% of the initial contract value. So that's, or 15% for works, and that's really just a sort of de minimis. If it's a really small change, then that's generally fine. So non-substantial changes there's a general allowance for that, but what non-substantial means is a really tricky area to get into. And just to run through some of the examples of what that means, well, so when is a change substantial? When is it not going to be a permitted modification? Well, if the change means that the contract is materially different in character, is it about, is the authority now procuring the design of a housing estate rather than the design of a primary school? That kind of, that's a big example, but something that's clearly just a different quality of contract to the one that was advertised. Would there have been a change potentially to the outcome of the tender or the hypothetical outcome? So would different people have bid? For example, would it have changed the balance of things? Changed the economic balance, so a change to the contract that means that it now favors the supplier more than it previously did. There are more suppliers might have originally bid if they'd known that was going to happen. So it's not an insubstantial change if the authority modifies a contract to favor the supplier once the contract is in place. Material extensions to the scope, so that's similar in a sense to different in character, but really it's just making a contract bigger rather than different, and a change to the contractor itself other than within the circumstances that I set out is obviously going to be a substantial change. So what are the consequences if a modification is made that is not allowed? Well, effectively what the regulations require contracting authorities to do is make sure that in any contract that they sign with a supplier, they include within that contract a provision enabling them to terminate the contract if it is subject to a substantial modification, which would have required a new procurement procedure. But if they don't do that, then the regulations apply one in anyway. So effectively, the authority has the ability and the obligation then to walk away from the contract because it can't just modify it in those circumstances. So clarifications. And clarification is obviously part of the procurement process, where either the authority is asking you to clarify part of your bid, or where you are asking the authority to clarify what it is asking, what it wants. We're talking about it here really more in the sense of when the authority is asking you for clarifications. And the reason for that is that this ties into to the ability of the contracting authority to get around the time limits and the deadlines and all of those things by asking follow-up questions, rather than just taking what it's been given by potential bidder or by bidders by the deadline. So Regulation 57 says this, that, well, you can read it for yourselves, but effectively where information or documentation that has been submitted appears to have bits missing or bits that are wrong, then it can request that you submit, supplement, clarify, or complete those within appropriate time limit, as long as that's done in accordance with the principles that Charles set out. So how does that work in practice? Well, there's we've mentioned, we've used councils as the example here, but this applies to any public bodies. So there's more scope for clarifications where it is just clarifying what's in the original tender rather than trying to add information. And there's not really scope for the public body, the buyer, to drive as much clarification out of you as it might like. If it's incomplete or erroneous, there's a fair amount of judgment on the public body to decide on whether it thinks that there is something that's wrong here, but it has to be careful. It may request clarifications from you if it thinks that something in your bid appears incomplete or appears wrong, but it doesn't have to. And it does have to comply with its duties of equal treatment and proportionality here. It has to do this within an appropriate time limit as well, and it has to do it, just overriding rule here is everything has to be in compliance with equal treatment and transparency. So every bidder has to be treated the same. If one bidder is being asked to clarify something, then everyone should be asked to clarify something. And if you're bidding on a contract and the submissions are over and the public body is asking one of the other bidders to clarify something in its contract that's unclear, but it doesn't ask you to clarify it, it just marks you down for something that's missing or appears wrong, then that may be a breach of the equal treatment requirements, because it's giving that other bidder a more of an opportunity to fix its bid, to fix those errors or missing bits than it's giving you.
Yeah, I think it's probably fair to say, Jamie, that the final bullet point there kind of overrides the others. You know, if you just look at the rule, it looks like there's quite a lot of scope to clarify things, but actually it's really hemmed in by the principles. So you're almost always better actually just looking at it from the perspective of the principles and seeing, will the principles permit it, and if they won't, then you don't need to get into the rest of the rule, and if they will, then they will probably only permit it because you're following the rule anyway.
No, definitely. So this is just a quick note on how this then works with non-compliant tenders, because obviously you've got a very fine line potentially between a tender that's just not doing what it needs to do. There's mandatory questions, mandatory requirements, accounts, whatever that are missing, but then how that interacts with the clarification side and the public body asking for more information as a follow-up. So there are risks in the process of the public body asking for more. There's also risks of them rejecting bids without allowing clarification. You know, is that a proportionate response if there's something missing? There are certain rules here around, you know, whether something clearly existed, and you know, is it disproportionate to say ask for accounts that did exist before the tender deadline closed, compared to, you know, qualitative answers or designs or something where actually giving you the extra time or giving your competitor the extra time gives more time to do something that hadn't been done by the deadline. And this is just about how the duties that public bodies have when they're doing this compete with each other. But there's also problems here because the public body is going to be trying to get the best outcome it can get, but that doesn't always tie into following the right process. So everyone involved essentially has to be a bit careful about how this works. And we've just listed a few of the cases there. There's not really any need to go through them in any detail, but these are some of the examples of where this has happened in practice. So Leadbetter was about missing case studies, and it was held that the court didn't, beg your pardon, the buyer didn't have a general duty to allow a bidder to correct missing things. It may or may not have a discretion to do so depending on what it is put in the ITT. Demmaster was about missing financial information, so a blank template was submitted rather than what was meant to be in it. That was seen as an obvious error and an easily rectifiable error. You know, it's financial information, it would have existed, but there was still no duty on the public body to allow it. And this is the key thing. Public bodies may have discretion to permit clarifications and fixing of things, but they don't have a duty to do so, generally speaking. Jones Legal Services Commission, so there was an issue here with the contracting authority being partially to blame for the missing information, and you know, whether that was whether it was therefore part of the principle of proportionality for them to exclude somebody from a process who only failed to meet up to something because of an error of the buyer. And then Manova is the sort of the key example of a case about that pre-existing information. So if a clarification can permit something that clearly existed before the deadline to be added, then it may be a proportionate thing to allow that to be submitted following the deadline, provided that the authority and the ITT and so on has left that open as an option. The key things here about managing the risk, well, from your side, you know, make sure you know the ITT documents are clear. You know what's being asked of you when you are making a submission. Essentially, the clock starts ticking as soon as you see a problem, and you've got 30 days from then. So you can't wait and then see if you win the contract and then decide whether or not you're going to challenge something. If you see a problem in the ITT, if it's asking a question that you don't think it should or can be asking, if it doesn't make sense in the process it's seeking to go through, then that's the time to complain when you see that, rather than waiting. And we've just got a few pointers there about, you know, just follow a checklist, making sure that all the information is done the right way the first time. Save yourself the hassle of getting into this clarification rigmarole with a buyer, because it's just far too complex to get into. They have too many too many opportunities to say no effectively. It's hard to force a contracting authority to allow you to do that. So some other lessons from recent case law, which I'll try to go through fairly quickly, so we've got as much time as possible for questions. Abandoning a procedure. West Sussex case was effectively about, you know, whether wafer thin decisions were a problem, and whether it was possible for the authority just to abandon a procurement. Effectively, the public bodies have quite a lot of discretion to abandon a procurement. You know, by and large, you will be aware that they fit into an ITT as a general rule, that they're not obliged to award the contract to anyone. They're not obliged to go through with it, and that's fairly standard. But what really comes out of West Sussex is this: abandoning a public body, a buyer that abandons a procurement process, doesn't mean that somebody who's claiming damages simply has to walk away. And the reason for that is that if the challenger, if you're challenging a procurement exercise and you would have won, you think, if it hadn't been for things being done wrong, then it's not really enough necessarily for the public body to abandon the procurement and start again, because it's putting you to the cost and expense of going through all of that all over again, when if they'd just done it right the first time, you would have won and you would have walked away with the contract and you would have had that profit. So a damages claim does survive abandonment of a procedure in some circumstances. Debrief information, there's been a fair few cases about how debrief information ought to work recently. Bromcom has happened during while we've all been locked down. And what that was really about was giving debrief information by Skype or Microsoft Teams interview rather than doing it by a formal letter. And the key lesson there is that this always needs to be in a formal letter, partly because that is what there always needs to be a formal letter because that's what the regulations require. But if other information is added in an interview, then it risks affecting the validity of the overall debrief process. So the general point there is that everything public body is telling you about why you didn't in particular win a contract really should be in the letter that they send you rather than trying to explain it in interviews. The Serco case is really just about disclosure and the rights of unsuccessful bidders to access information relating to the evaluation process. And really what that's saying is that that's going to be more common going forward, the ability of challengers to access that type of information. And public bodies will start to be aware of that. But it's also important for potential challengers to be aware of your rights in these circumstances. And the NDA case is really just one that I always enjoy listing, partly because it's an example of how it's possible to do absolutely everything wrong in a single procurement, including deciding to shred records and have witnesses lie on the stand in order to try and get away with the failures to procure properly a multi-billion-pound contract. That did not work out well for the Nuclear Decommissioning Authority. Ineffectiveness is something that we've come across more and more, shall we say. It's a fairly new remedy by sort of overarching standards, and it's something that is important to be aware of because it can keep applying to a contract for some time as a risk after it's been signed. So there are three grounds of ineffectiveness. What an ineffectiveness order is basically the court saying that contract has not been procured, has been procured in breach of very specific rules, and because it was procured in breach of those very specific rules, for up to 6 months after it has been signed, the court can simply declare it void. So you may think, or a buyer may think that it has managed to get away with something and sign the contract, and people are on the ground and people are doing work and they're incurring expense and so on. And then a challenger comes along and says, hang on, you've broken these specific rules, and therefore the court should declare it ineffective. So three grounds for ineffectiveness. The first one is that the authority has awarded a contract without advertising it, unless it was exempt. So if a direct award was an option, fine, but if direct award wasn't an option and the authority has made a direct award, then the contract can be declared ineffective even after it's come into force and effect. The second ground is that the authority has failed to follow certain procedural requirements about the awarding, the entering into of the contract. So if it hasn't observed the standstill period, if it's entered into it while automatic suspension was in place, and those things have prejudiced the ability of a challenger to bring proceedings, then in those circumstances it can also be declared ineffective. And the third ground there really more relates to awarding improperly call-off contracts under a framework agreement or a dynamic purchasing system. So in those certain circumstances, an ineffectiveness order can be made by the court, the contract is void. So authorities are trying to use more things called VET notices, voluntary ex-ante transparency notices. And what those are really saying is, we've not followed the rules. It's a published notice where the authority says, we've not followed the rules. This is, or we've not done this procedure. The reason we've not done this procedure is because the rules do not require us to do this procedure in these circumstances, and these circumstances are as follows. So it's not the public body saying we've broken the rules and we should get away with it. It's saying we've not followed the procedures, but that's because we don't think we have to, and this is why. So what a VEET notice can do is effectively protect a public body in the event that it turns out to be wrong about that. So if it's published a VEET notice, and this is on the first ground that I just outlined, if it's published a VEET notice and it turns out that actually it couldn't make a direct award, it made a direct award thinking it was allowed to, turns out it couldn't, what that means is that an ineffectiveness order cannot be made against that contract once it's been entered into. But it only allows, it only protects the contract the public body has given a direct award for, provided that the public body had a reasonable and genuine basis to believe that it could make that direct award. So it's not a sort of get out of jail free card in a way that a lot of public bodies sometimes are attracted to using it. And it's really important for suppliers to public bodies to be aware of this, because ultimately the risk is as much on you as it is on them if the contract is declared ineffective, because at that point it simply becomes unenforceable. And not just unenforceable, but nobody is permitted to actually carry on acting in compliance with it. And we've just listed a few of the problems there about when those go wrong, but really the key thing is either the authority doesn't genuinely believe it's acting in compliance with an exemption, or if it does, it doesn't really have any grounds for thinking that, or at least it's not said it properly in the notice. And then back to Charles for Brexit.
Thanks, Jamie. Just be a couple of minutes on this subject. And then we'll go to questions. So do put your questions into the chat. So what next? So Trade and Cooperation Agreement, that is the technical name of the UK-EU agreement reached in December. And the Trade and Cooperation Agreement does place requirements on either side to essentially keep their public procurement opportunities open to bidders from the other party. The UK's existing legislation and any new procurement legislation should not discriminate between UK registered or UK based contractors and contractors who are based elsewhere in the EU. Similarly, there is the World Trade Organization's Government Procurement Agreement, not quite as detailed, but certainly has a similar approach in that public contract opportunities should generally be open to businesses from countries that are parties to the government procurement agreement. So that's written into the procurement legislation if you ever have cause to look at it. But it does mean that for this particular audience, I think it's more likely to be if you're looking to get opportunities in other countries rather than what the UK rules say. But do keep in mind that you do have some protection if you're going into another jurisdiction. So the new UK FTS, that's the Find a Tender Service, has replaced the function that the Official Journal of the European Union previously carried out. FTS is now where contract notices, contract award notices, VEET notices, various other things are now published. And you may be most familiar with Public Contract Scotland. That feeds into the FTS service. So notices that are published on PCS will find their way onto FTS and so comply with the relevant requirements. The UK government is proposing to make changes to procurement law as it applies in England and Wales. Jamie, does it cover Northern Ireland as well?
No, I don't think at the moment it does.
Yeah, so at the moment, England, Wales, Northern Ireland are covered by the same set of regulations, but we may see some divergence there. As I said, Scotland already has its own regulations. So for England and Wales, the UK government is proposing to change the procurement regime. So some of the highlights, we're taking these from a green paper that was published by the government last year or early this year. the Queen's speech said that there would be a bill about this in the next Parliament, so should get more meat on the bones soon. But essentially, main points, the government's proposing replacement procedures. Going from the ones that I outlined to 3 procedures, one an open procedure, which would be for more of your sort of off-the-shelf type purchases, and presumably similar to the existing open procedure. What they describe as a flexible procedure that will give buyers some freedom to negotiate. So maybe something like the competitive dialogue or the competitive procedure with negotiation options that I outlined earlier. And then a limited procedure for urgent or emergency purchases, which will probably replace the sorts of things Jamie was talking about. They're proposing to introduce beneficial owner rules. So there would be a requirement to participate or in order to participate in a public procurement opportunity, the bidder would have to reveal their ultimate beneficial owner, and that beneficial owner would not have to be excluded because of the sorts of things I mentioned earlier, bribery, anti-competition, anti-competitive behavior, that sort of thing. Previously, there have been courts about this, there have been cases about this in the EU courts, where the courts have said all that matters is the status of the particular bidding party. So a parent company's wrongdoings can't be a basis for exclusion. The UK government's proposing to change that. They're also proposing to allow more economic, social and environmental criteria to be used, or rather, I suppose, more social and environmental criteria, whereas at the moment, the test is just most economically advantageous bid. And they're also looking at changing the rules around bringing challenges. So, and it looks like weakening the sort of facilitating provisions that I've mentioned. So, for example, ending automatic suspension in urgent situations. Obviously, the devil there is in the detail of how urgent situations is defined, and possibly also ending the requirement that each bidder get its own individual debrief letter setting out the reasons why its bid was not successful. In combination, those could make it very much harder or very, very much less likely that bidders will actually challenge procurement decisions, because they will have neither the procedures that facilitate that nor the information on which a challenge might be based. So we await to see what happens there. But in terms of the position in Scotland, there's no plans to change the rules there. We've said yet. I think there is a bit of a tension there, in that the Scottish government has been keen to try and bring in things like social and environmental criteria. They've probably been pushing for that more than the rules would actually allow authorities to implement. So there would now be scope for them to do something like that, but the reason for the tension is that the Scottish government has a policy, and indeed has a power, to keep Scots law as close to EU law as possible in areas that are within the Scottish Parliament's competence. And obviously procurement rules are EU derived, and there's therefore that tension there. At the moment, the Scottish Government hasn't said anything about wanting to depart from the existing EU derived procurement rules, and what they call their keeping pace policy would suggest that they shouldn't want to do that, but we'll see if that stands the test of time, particularly if England and Wales adopts a particularly different procedure, and if English public authorities as a result get to do more of the things that Scottish public authorities would probably quite like to do, including having fewer challenges. So we'll see what happens with that in the future. Okay, so that's our presentation. Very happy to take any questions. Maybe Jamie put up our contact details in the meantime, in case anybody has questions they don't want to ask in an open forum.
That's a good point. Thanks to you both. First of all, that was super interesting, lots of information. I won't pretend that some of it didn't go a bit over my head, but I can always come back to you in detail when I have a specific question, which I don't at the moment, but please, anybody who's in the room, just type in the chat if you have a question for either Jamie or Charles. We just wait a bit. There's so much to know.
Yeah, it's not the most straightforward regime in the world.
No. you just hope you never get to the stage where you have to actually come to you guys and ask for advice.
Yeah, I mean, on that, you know, we're always, or we're often kind of a distressed purchase. We're not necessarily something that people are keen to spend money on. But just emphasize the point that Jamie made earlier, that if an issue, when an issue arises, it kind of needs to be tackled at the time, because there's that 30-day time period for court action. And even if you have no intention of taking court action, the sort of underlying threat of that is usually what will give you any prospect of persuading a public authority to change their mind. If you flag an issue to them that they are clear it's now too late for anybody to complain about in court, then they're probably unlikely to undo their procurement exercise as a result of that. So yeah, early engagement is often not particularly desirable, but if it needs to be done, it's best to do it early.
Yeah. Okay. That's useful advice. I think there don't seem to be any questions, so I just thank you both again. That was really interesting, as I say, and as we will record, or rather publish the recording of this event on our website, all the details will be there for the participants to see, and anybody else who's interested. And just to say, the next event will also be with Brody's, with Stephanie Clark and Manus Quigg, who will be talking about time bar on claims relating to design defects, and that's on the 8th of June, which is a Tuesday. So thank you both, and thanks everybody. And I just close with that. Okay.